Away we go. So I'll give a couple of opening remarks, and then we'll kick it over to my good friend Pavan, and he's going to talk about what's changed in Virginia's employment law. So good morning, and thank you for attending. I hope you're as eager as I am to learn more about Virginia's employment laws and how they've radically changed. Just a quick note, we are providing ideas and resources, but not specific guidance or recommendations for you or your unique business situations, whether it's a law or insurance and benefits. Pat and I are more than happy to engage with you and your company individually as part of your advising team in our individual disciplines to provide consulting and tailored recommendations to you and your leadership team. So, okay, so let's get moving. We have about an hour. This webinar is pending approval for one SHRM credit and one HRCI credit. I know for those of you that might have been on a webinar last week, I just got the HRCI credit in today. It just sometimes takes some time, and my good friend Trisha, who helps with this, she's in the middle of a move, and she's awesome, but it takes some time. So these certificates, assuming that everything goes through the approval process, it'll probably be a few days, maybe even next week before they come out. Just be patient with me. I will email them to you once I have them in hand. We are recording this webinar, both for those who are registered and miss it, and those who want to review it again, or if you want to share it with a colleague. You'll receive a link for how to view that in the post-webinar email. That'll actually take you to a YouTube site that you can see other webinars that I've done in the past couple of months. Please use the Q&A feature for questions that you would like to kind of delve in to more deeply with Pavan. So let's jump right in so we can get finished on time at 11. So just as a quick note, most of you that have registered for this probably know me, but my name is Brian Klickener. I'm with Risk Strategies. Risk Strategies is an insurance agency, a boutique insurance agency. We have over 1,800 employees in 70 offices around the U.S., not including my home office, Casa de Klickener. So we have a lot more now given the pandemic, much more than 70. Here at Risk Strategies, my team and I work with clients to create bespoke employee benefits programs. What's bespoke? Basically, it means, hey, we're trying to tailor them to what your needs are, trying to integrate benefits along with policies so that they come connected, not just throwing products at you and trying to solve problems with products. We want to understand what you're doing. So if you're interested in a different way to kind of manage one of probably your top corporate expenses, maybe it's number 2 or number 3, set up a Zoom chat. I'm happy to be short on my side and talk with you about that. So my good friend Pavan Khoobchandani, Pavan's law practice regularly represents employers with respect to all types of employment issues. He advises clients with respect to discrimination and EEO challenges, employee relations, employee engagement best practices, inclusion and diversity, and HR policies and procedures, as well as he drafts and edits employee handbooks using best practices from a broad spectrum of industries, employment and separation agreements, as well as other HR documents. I've worked with Pavan in the past, actually, during my GovCon days. I worked with him for a number of years. He was of counsel to the company that I was working for at the time, and had the opportunity to kind of see him in action, and came to respect him as a professional, but also became a good friend of his as well. Or he became a good friend of mine, rather, I guess is a better way to say that. So with that, I'll pass the mic to Pavan, and away we go.
Well, thank you very much. That's very, very kind words. And yeah, it was great to work with you. You were always on, you are, and we're always on the ball. So I definitely appreciate that. Thank you, Brian, for having me. Thank you all for being here. So like Brian said, I'm an employment attorney. I represent employers, meaning companies. Sometimes people call that a management side attorney. What I really like to do is work with companies that don't have in-house attorneys or in-house general counsel. And the reason is that oftentimes when you have an attorney on staff, they play this role of being a watchdog and looking out for risks and sort of being in the business and having their eyes on everything. And a lot of executives do this, absolutely, for sure. But it often helps to have an extra set of eyes to do that. Honestly, for most companies, having an in-house attorney is just, it's not really feasible. And so that's a gap that I like to try to fill. What I like to do is work with companies before they get into trouble, to help them avoid missteps, help them avoid lawsuits, things like that. So that's what I would like to do today a little bit. Give you some information to try to hopefully stay out of trouble. So I'm going to do this. 1 second here. Okay. So I think you can see my screen. I'm titling this presentation, Employers, Get Out Your Checkbooks, which hear me out. I think it's a very fitting for a number of reasons. Number one, the changes that are coming to Virginia employment laws are, for most Virginia employers, going to be unexpected, especially for people that haven't been following what's going on in the past months, year in Virginia. It could be a little bit of a surprise. Number two, these changes are unprecedented in Virginia. I'm going to talk about that a little bit. And number three, honestly, I think they have the potential to change new laws to be very expensive in terms of lawsuits by employees against companies. Look, I know that fewer and fewer people are using checks, so the concept of a checkbook, some of you may not really even understand it. But I think the checkbook metaphor is fitting because Virginia is not normally, until maybe now, but historically hasn't been one where one thinks about progressiveness. Okay, a little example. Unlike every other state, when I took the bar and up till last year, the bar exam for attorneys, the Virginia State Bar, who administers that exam, requires everyone taking a 2-day exam to wear court attire, a suit and a tie, to take a test. And you're sitting there in this huge place taking it because decorum, right? It's Virginia, decorum. The test takes place in this huge room, convention center, and because the testing sites have hard floors that would amplify, if someone got up to go to the bathroom, it would amplify the sound of hard shoes. You gotta wear a suit, but you gotta wear soft-soled shoes. Oh, but you can't wear sneakers because decorum, that would not be proper. So I remember I had to go buy a pair of soft-soled, non-sneaker shoes. The point is, look, Virginia has been an employer-friendly state forever. Last year, Oxfam rated Virginia the worst state for workers' rights for the second year in a row, and CNBC ranked it as the best state for businesses. Those are not unrelated. But that's all changing with the new laws that have been recently enacted by the Virginia Assembly, the Virginia legislature. What's happened is that for the first time in decades, Democrats control both chambers of the Virginia Assembly, and the governor is a Democrat. And so they've taken that opportunity to push through some laws that, in my opinion, and I don't think anyone disagrees with this, would have been unheard of in Virginia just a few years ago, even though they've been, other states have been moving towards some of these laws. So what I want to do today is go over some of the major changes that Virginia employers need to be aware of to keep that checkbook put in your locked drawer. I don't know why I'm going all in on this checkbook metaphor, but sorry, bear with me. So this is going to be an overview of some of the changes going into effect July 1st of this year. So it is, a little bit over a month. What I'd like you to come away with, if nothing else, is the realization that Virginia employers are going to need to be more diligent in making sure that they comply with laws, and especially when discharging or disciplining employees. I've had a lot of Virginia clients say to me, you know what, I'm just going to do this. This person's not going to be able to find an attorney. This person doesn't speak good English. This person doesn't have the resources. This person, blah, blah, blah. They're not going to be able to find an attorney. I think with these new laws, and we're going to go through why this is, it's going to be really easy to find an attorney to bring a lawsuit, and then for an employee to find an attorney to bring a lawsuit against an employer in Virginia. So that risk analysis of, oh, this person won't sue, I think is going away. So what we're going to talk about today is, this is a quick little agenda, the Virginia Values Act. We're going to talk about a ban on non-compete restrictive covenants for low-wage employees in quotes. We're going to talk about some changes to the wage theft law in Virginia, some changes to worker misclassification, so whether someone's an employee or an independent contractor. I'm going to touch on real quick some changes with respect to marijuana decriminalization and new whistleblower protections. All right, so let's jump into it. The Virginia Values Act. Okay. The new Virginia Values Act is probably the biggest change to Virginia law of everything that's changing on July 1st. And what it is an expansion of the Virginia Human Rights Act. And when I say expansion, I mean they threw it away. They threw out the Virginia Human Rights Act and they enacted a new one. And we're gonna talk about that. So it goes into effect like July 1st, like we talked about. I think pretty much all the laws that I'm talking about today are going to affect July 1st. So Virginia is gonna join 21 other states and the District of Columbia in making it unlawful for private employers to discriminate on the basis of sexual orientation or gender identity. It's gonna be the first Southern state to enact these broad protections for LGBTQ plus employees. This is big. If you read articles about this, people are using words like sweeping, seismic, fundamental change to describe the new law, because that's what it is. And one article I read said that, suggested, and I don't disagree with this, we just talked about it, that this new law is going to make Virginia a hotbed for employment litigation. I don't think I need to tell you that hotbed for employment litigation are not words that an employer wants to hear when talking about the state in which it operates. But here we are. So let's get through it together. Just one note on sexual orientation and gender identity. These are two protected categories that are not yet protected by Title VII of the Civil Rights Act. There's no federal protection for private employers for sexual orientation and gender identity. There's a Supreme Court case pending right now on this issue that could be ruled upon in June. Very, very soon, within the coming weeks, we expect a ruling on that. So there may be some changes coming federally, but in the meantime, July 1st for sure, we're going to see these changes. Okay. So for Virginia employers, what the Virginia Value Act does is pretty epic. The Virginia Human Rights Act, many states have individual human rights act that provide protection, sometimes a little bit more, sometimes a little bit less than federal laws. But when an employee sues, oftentimes they'll sue under the federal Title VII or whatever federal anti-discrimination statute, and they'll also sue under the state Human Rights Act, the state equivalent. So that's, and there's different standards, there's different damage awards between federal laws and state laws, and so that's why you have a little bit of a mishmash. But anyway, okay. So before, the Virginia Human Rights Act was originally designed to apply to employers with more than 5 but less than 15 employees, so 6 to 14 employees. It was very narrow. If you had more than 15 employees, Virginia said, hey, you're subject to the federal laws, okay? There's not really any significant Virginia law that protects against discrimination. But now the Virginia Human Rights Act has changed. Make a note here. So the Virginia Human Rights, so I said it only applied to employers of 6 to 14 employees. Sexual orientation and gender identity were protected categories, and the Virginia Human Rights Act before limited damages to 12 months of back pay, and it had an attorney fee cap saying, hey, if you get damages, back pay damages of this much, you can only have attorney fees, some portion of that. And it only applied if an employee was terminated. It didn't apply to all employment actions like demoting someone, not hiring someone, changing someone's job as retaliation or discrimination. It didn't apply. It was this quaint little law akin to so many quaint Virginia country towns that I wish I could go visit right now. Okay, starting July 1st, that's all changing. The new Virginia Human Rights Act will apply to all employers with more than 5 employees, more than 5 and up, okay? For employers with more than 5 but less than 15, so for that that small group of narrow group of employees, the new law is going to prohibit unlawful discharge. So that's sort of that part's the same. It prevents discrimination in the context of unlawful discharge. But it adds sexual orientation and gender identity to that. Now, for employers with 15 or more employees, the new law will prohibit not only unlawful discharge, but unlawful employment practices. That's broader than unlawful discharge. It includes unlawful discharge, but it also includes failing or refusing to hire someone or otherwise discriminating against an employee in any way. There's a little quirk when it comes to age discrimination, like the Virginia laws protecting against age discrimination. There still is not going to be a Virginia law that protects age discrimination for employers with more than 20 employees, but there's federal laws that protect them. But put that aside for now. So the Virginia Value Act, so it broadened the number of employers that it applies to. It also removed the cap on damages. So now an employee may be awarded uncapped compensatory damages, which is broader than they could get under some federal laws. Employees can get punitive damages to $350,000, and they can get reasonable attorney fees, not attorney fees that are capped as a portion of the damage award that they get. So what this means is a broader group of employers are going to be subject to the Virginia Human Rights Act, and these employers are going to be subject to discrimination laws that are broader than the current federal laws. And the employers could be forced to litigate in state courts. So let me just talk a little bit, because this is sort of big. Let me talk a little bit about courts. So employers generally like to be in federal court for a lot of different reasons. In Virginia, one of the biggest reasons that employers like to be in federal court is because in federal court, you can get what's known as summary judgment. It allows an employer to file a motion in the middle of a case and saying, hey, listen, employee's got no case here. You got to kick this out. And employers regularly win summary judgment motions, get lawsuits dismissed in the middle, as opposed to having going all the way to trial. Okay. Now, there's a quirk in Virginia courts. These quirk a lot because this is kind of quirky. It's very difficult to get summary judgment in a Virginia state court. Okay. Because you can't use deposition transcripts, you can't use affidavits, but needless to say, it's difficult to get summary judgment in Virginia state court. So what that means is if you're an employer in Virginia state court, you're not going to get out probably in the middle of the case. You're going to take, if you don't settle it, you're going to take that all the way to trial. That's expensive. I have won a summary judgment motion in Virginia state court, and I'm actually going to talk about the case a little bit later. Even so, when a employee sues a employer in state court, and they have like a federal claim, like a Title VII claim or an ADA claim, and remember I told you there was this sort of similar state law claim. When they have them both, an employer oftentimes can remove the case. It's called removing it to federal courts. You file something in federal court, say, hey, listen, there's a federal issue here. State court can't hear the federal issue. We're going to move this case to federal court. And employers love that, right? Because federal courts tend to be faster, although Fairfax County is a fast court. If federal courts tend to be faster, you can get summary judgment. That's where employers want to be. What we expect to see is Virginia employees leaving out that federal cause of action. We expect to see them file in state court only with the state law claim. And it's going to be much harder and much less, it's not going to happen as much for employers to be able to remove that. If there's no federal question, there's a different criteria for removing it to federal court. That's not going to apply as much. So you're going to have all these employers that are forced to litigate in Virginia state court where they don't want to be, and they can't get summary judgment. That's a hotbed for employment litigation. A couple other things to note. The Virginia Human Rights Act has also been amended to add protections for childbirth, pregnancy discrimination and accommodation, and protections for hairstyle, hair texture, and hair type. And so the new law is going to protect employees from being discriminated against based on their hair. You know, for example, whether they wear it in braids and locks and twists, there's going to be protections there. And that ban on hairstyle discrimination is it's a prime example of how progressive these laws are. Virginia's only the fourth statewide to enact this type of legislation. You know what the other states are? California, which is known to be employee friendly. New York, New Jersey, much more progressive states to start with. There's pending with respect to hairstyle discrimination. There is legislation pending in a lot of other states, but Virginia is the fourth one. That should tell you something about how big what we're talking about is. By the way, we're going to talk about posters later, but there is a poster for the new pregnancy law that employers need to put up where you put all your FLSA and Virginia and wage and hour workers, all the posters. There's a new poster that needs to be, or there will be a new poster. It's a posting requirement. You'll have to see. Okay. Moving on. So the Virginia Values Act, the Virginia Human Rights Act, that was I think one of the biggest things. Another pretty big thing I wanted to talk about for a second is a ban on non-compete agreements for what's termed low-wage employees. Whether or not businesses can require that their employees enter into non-competes varies from state to state, okay? So right now there's no federal law that governs non-competes. There has been a push in the past few years for, in many states, to enact legislation either banning non-competes or restricting them, like what Virginia has done in various circumstances. In 2015, so 5 years ago, Hawaii banned non-competes for high-tech workers, not low-wage workers, high-tech, which actually probably aren't that low wage. The argument there was that prohibiting employees from jumping, that's what a non-compete does. It sort of prohibits you from going to a competitor. Prohibiting employees from jumping from one company to another discourages entrepreneurship. Like, it discourages people starting their own thing or finding a better job, going somewhere else. And enacting that law was an attempt to stimulate Hawaii's economy, probably draw more people workers to Hawaii as well. More commonly, so that was Hawaii fun. More commonly, however, states have restricted the use of non-competes for low-wage workers. This was in very large part, in response to President Obama in 2016. He issued a call of action to states regarding non-competes and said, hey, workers have been forced in this country to sign non-competes when they work at sandwich shops, doggy daycares, grooming services, summer camps, warehouses. None of these jobs involve like trade secrets or proprietary information that would justify a non-compete. All it's doing is being punitive, was the argument. And what it's doing is restraining the ability of employees to seek better pay and working conditions somewhere else. So Obama asked state policymakers to change laws regarding non-competes, and they did it. And what the White House was looking for was to better protect what they termed ordinary workers. And the idea behind all of this is that non-compete agreements contribute to weak wage growth. The reason is it's sort of a common understanding that changing jobs, moving from one company to another is really how workers can get a big raise and how they can raise their salaries. Like, you can work incrementally within a company, but really moving is when people make these big jumps. So because if you restrict people from moving, you're restricting them from making more money. So many states got to work and they have enacted legislation regarding non-competes, and Virginia is one of them. The Virginia law states that after July 1st, an employer may not enter into, enforce, or threaten to enforce a covenant not to compete with any low-wage employee. Seems simple, right? You got to delve a little bit deeper into what these bolded words mean. to understand what the law actually says. So first, what is a covenant not to compete? There's a definition in the new law, and it says that a covenant not to compete it's a restraint on an individual's ability to compete with his former employee, with his former employer. Yeah, that's what it said. The law says that a covenant not to compete is a restraint on an individual's ability to compete with his former employer. Why does it say his as opposed to its or his or her or their? It's still Virginia, I guess. No matter, you could take the anyway. All right. So a covenant not to compete is a restriction on the ability to compete. Like, okay, that's not really helpful. What the law does, it prohibits traditional non-competes, right? I think most of us know what a traditional non-compete is. After you leave here for 1 year or 2 years, you can't go work for a competitor. The law seems to also bar some non-solicit clauses. Oftentimes, and non-compete can be part of an employment agreement, or it can be its own standalone document. But oftentimes, there's a non-compete and a non-solicit clause that go together. And the new law prohibits, it bars agreements that would prohibit an employee from providing a service to a customer or client of the employer if that employee didn't initiate the contact. So, employee goes and starts his own business, doesn't seek anyone out, just puts an ad out. And people come to that employee, people come to him or her. You can't have a non-compete agreement. A non-compete agreement that would bar that situation would not be legal. There may be some non-solicit clauses that are allowed. The law specifically says that employers can continue to have confidentiality agreements with employees, protecting trade secrets, proprietary or confidential information. Employees regularly use these, and there are laws that protect employees from taking your information and moving to another company. It's really hard to prove that someone took confidential information and went to another company and used it. That's why you have non-competes, because you're like, I'm not even going to let this employee get into this situation where they may even have the opportunity to use this information. But for low-wage employees, the non-competes are going to be banned. So what is low wage? Low wage does not mean low wage. Low wage, the law says that it applies to employees earning, less than the average weekly wage of the Commonwealth of Virginia, okay? Which on July 1st, 2020 is going to be $1,137, which is $59,124 annually. The law says for an employee that earns less than $60,000, you can't make them sign a non-compete. $60,000 is not low wage. I will not accept that anyone telling me that $60,000 is low wage. What the law actually says is that it's the average wage, and so by definition, the law applies to employees that are lower than the average wage. So that's what it is. All right, so we talked about what a covenant not to compete is. We talked about low wages. So what an employee is probably clear, right? No. An employee doesn't only mean an employee. The law also protects independent contractors that have hourly rates that are less than the median hourly wage for all occupations for the previous year, which is $19.63 per hour in 2019. $19.63 for an independent, depending on what industry you're in, that is a pretty low wage. But remember, who are we trying to protect here? And we'll talk about that in a second. So employee doesn't only mean employee, it means employee and independent contractors. And also by employee, they don't mean all employees, because it excludes employees whose earnings are derived in whole or predominant part from sales commissions, incentives, or bonuses. Predominant part is not defined. But I think it's safe to say that the law probably doesn't prohibit non-competes for employees that traditionally employers have considered the biggest risk to their businesses if they were to go to a competitor. And that's commission salespeople. I mean, commission salespeople, their job is to have customer lists and know their customers really, really well and talk to them every single day. This is not retail this is not retail salespeople. We're talking about, internal and outside salespeople for companies that are commissioned. Okay, so what does this mean for employers? The law has a new private right of action. So if an employer improperly makes an employee sign a non-compete and then goes to enforce it, the employee can sue the employer. And the court can invalidate the non-compete. The court can order the payment of liquidated damages, can award loss compensation, and attorney's fees. And again, it's going to be in state court, not in federal court, where it's the hotbed. Remember the hotbed. The law also provides for civil penalties of $10,000 per violation. That would be a penalty by the Commonwealth of Virginia. That's a lot. That's a lot of money. And the kind of good thing here is that the law only applies to non-competes entered into on or after July 1st, 2020. So your existing non-competes won't be effective. So you could arguably you could enter into a non-compete on June 30th and would be able to go ahead and enforce that after July 1st. So what do employers need to do? Let me see here. Post a copy. This is the second post that I'm talking about. Post a copy that is either the text of the new law, we know, again, where your notices are posted, or a summary that's approved by the Virginia Department of Labor. I checked yesterday, I didn't see an approved summary yet, but it'll be coming out. The fact sheets that Department of Labor, federal and state, put out one of those. So do that. I think that employers should figure out whether you have any employees or workers that would be covered under this law. Like, as you do your hiring, think about, do I regularly have employees that are covered by this law enter into non-competes? And if the answer is yes, stop doing that, because that's going to be illegal. Or if you think that non-compete is really important, you might want to think about whether you should pay that employee more, so that they wouldn't be covered by that law. And remember, that amount of the law is not a fixed amount. The amount of the average wage, which is $1,137 on July 1st, 2020, that's going to change. And then there's a way of calculating what the employee's salary is and what the average wage is. But if you're anywhere near this amount, and you have employees that sign non-compete, that's something you need to think about. This might be a good time for employers, as a general matter, to look at other non-competes they have that wouldn't be affected by this law. Even before this law, Virginia courts have disfavored non-competes unless they were pretty narrow. I've seen a whole lot of overly broad non-competes that would not stand the scrutiny of a court. And I've had employers pretty universally telling me, I know this is not enforceable. I just have my employees sign it as a deterrent. Again, these employees aren't going to go find an attorney. My employees are, when they sign a document, they stand by their word. And so, you know what? I know this is not enforceable. I want to go ahead and have employees sign it. No, you gotta stop doing that, because there's significant penalties if you do continue to act this way. There's going to be a whole lot of attorneys out there, plaintiff side, employment side attorneys, that are going to be jumping on this. First of all, a lot of them have been laid off from their firms during the COVID-19 crisis. They need work. And second of all, this is going to be lucrative. These new laws, most of them, if not all of them, provide for the recovery of attorney's fees by the employee. Okay? It's going to be a hotbed. At some point in time, I'll stop saying checkbook and I'll stop saying hotbed, but not today. Look, I just want to take 1 second. I have a personal feeling about this law. I talked about this case a little bit earlier. One of the people that I represented early in my career was a low-level locksmith in Arlington, Virginia. Okay, he had a non-compete with his employer. My client, the locksmith, moved to Prince William County, was starting a family, wanted to move to Prince William County, got a big house. And he went to a company down there. He didn't want to have to travel all the way up 95. He wanted to just sort of work in that area. He did lockouts, he did car dealerships. And he had spent a lot of time learning, especially with locksmith nowadays, it's not only keys, it's key fobs. You spend a lot of time learning how to do it well. You spend a lot of time learning how to, there's a lot of tricks of the trade. And so it's not something you can just pick up. The Arlington employer sues my client, trying to enforce, saying, hey, you have a non-compete with me. I'm going to enforce the non-compete, and I'm going to try to prohibit you from working anywhere in Virginia. So, like I said, my client had spent years on trying to become good at a locksmith, and that was all he really knew how to do. And basically, it would mean that he wouldn't be able to work and make anywhere near as much money for a very, very long time. But look, there's a lot of locksmiths. There's a lot of work to go around, and it seemed really unfair to me to make this guy who got really good at something stop doing it. Ultimately, we were able to get the non-compete voided by the Fairfax County Circuit Court. But that was after my client had to spend money on legal fees. And there was no recovery attorney's fees provision. With this new law, that won't happen. And I honestly don't think that's a bad thing. I think that non-competes have their place, absolutely. But at least the intent of this law, when thinking about low-wage workers, I haven't really seen a low-wage worker that it would be proper to have a non-compete with. So that is where we are on non-compete. So if you have non-competes, you take a look at that. All right. There's changes to the new wage theft law. Okay, so what is wage theft? Wage theft can take many forms, but and obviously it's intentionally not paying someone for work they did, withholding wages. But it also includes things in a little bit of a gray area, such as failure to pay overtime, illegal deductions from an employee's pay because of something they broke, or like some money they owe to the employee. You see this a lot in final paycheck. Oh, you owe me X amount of money because you were negative in your leave balance, or you owe me X amount of money because you didn't return your laptop, or you did, or whatever. There's pretty strict laws under the Virginia Wage Pay Act. There's pretty strict laws regarding wages. Hourly employees have to be paid twice per month. You can deduct this. You cannot deduct that from wages. You have to pay the final paycheck by this date. But the law didn't provide employees with a private right of action to enforce those laws until this point. Before, if an employer improperly withheld wages, an employee couldn't sue them. They had to go to file an administrative claim with the Virginia Department of Labor and Industries. And if there was a situation, then the Virginia would come after the employer. But employers rarely faced wage and hour lawsuits in state court. Now, employees are going to be able to file in state court, hotbed, either individually or jointly with other aggrieved employees, like a collective action under the FLSA. They're going to be able to file these lawsuits, and they're going to be able to recover wages owed. They're going to be able to recover an additional amount of the wage, whatever the wages were owed, the same amount, double it for liquidated damages and prejudgment interest. They're going to be able to recover attorney's fees and costs, which again is going to allow them to get into court. You're going to have a lot of attorneys that are going to see that and are really going to jump on it. If the court finds that an employer knowingly failed to pay wages to an employee, like intentionally did something, the law says that the courts shall award triple damages as well as attorney's fees costs. Oh, and by the way, the law says that there could be criminal penalties for knowing wage theft. That's jail time. That's fines and jail time. We're gonna have to see how that plays out, who it's gonna be that potentially has the jail time, but that's what the law says. It's not something you want to be the test case on. Another new law allows the Virginia Department of Labor and Industry to investigate an employer's failure to pay wages in accordance with the Virginia Wage Payment Act. And what it does, it gives the Department of Labor the authority to investigate whether the employer has failed to pay wages to other employees. So like employee A complains to the Department of Labor. Department of Labor comes in and looks, and Department of Labor and Industries comes to a reasonable belief that there may be other attorneys that also didn't get their wages paid properly. They could start looking into that. That's scary to me. I don't think it's ever a good thing when a state or a federal agency comes sniffing around my clients' businesses. And any kind of audit, any kind of DOL, my advice always is do everything you can to keep them away. I think employers should try to avoid that if at all possible. And the way to do that is to be really strict on the decisions you make when you're trying to deduct from employees' wages. All right, and worker misclassification. Okay, so there's a number of new laws that are trying to, there's a bunch of them that are trying to combat improper worker classifications. There's a lot of reasons why an employee may be misclassified as an independent contractor as opposed to an employee. One is that the employer misclassifies an employee because they want to save on employment taxes. An independent contractor pays their own taxes. An employee, you got to pay Social Security, Medicaid. It's more expensive. Honestly, in Virginia, especially in Northern Virginia, there's a lot of industries where the employees themselves want to be classified as an independent contractor. They call it 1099 employee. I want to be a 1099 employee. Or you'll have employers saying, hey, you want to be a W-2 or a 1099 employee? A 1099 is the IRS form for independent contractors. An employee is an employee. Like a 1099 employee is not a thing, okay? But that's what's happening. There are industries where misclassification is rampant. The construction industry is always touted as the one where independent misclassification is a really big problem. I think that one of the big reasons is employers think that for independent contractors, they don't have to verify immigration status or employment eligibility, and so they can hire people they otherwise wouldn't be able to hire. Independent contractors, you don't have to pay overtime, right? You don't even have to pay minimum wage. Minimum wage laws don't apply to independent contractors. The FLSA doesn't apply. So you see that a lot of construction in the construction industry, and lots of states are taking action against that. IT industry, it's very common in where workers jump from one government contracting industry, when workers jump from one government contract to another government contract. They're like, it's just easier. I'll just be a 1099. The thing I like to tell employees, if you have two workers sitting side by side, metaphorically, doing the same thing, and one of them is an employee and the other one is an independent contractor, or classified as an employee and the other one's classified as an independent contractor, it's likely that one of them is misclassified. They're doing the same job. So Virginia's taking a harder stance on these independent contractor classifications. One law creates a private right of action, hotbed for misclassifying an employee as an independent contractor. It creates a presumption that if you're paying someone, that they're your employee. That presumption, the employer can rebut that presumption if the employer can show that this worker is an independent contractor under the IRS guidelines. Now, IRS cares about misclassification because what we talked about before, it loses tax revenue if a worker is classified as an independent contractor rather than an employee. It's much easier for the IRS to collect taxes from the employer, for a finite number of employers, than it is from all the independent contractors out there that may or may not file their taxes, may or may not withhold, may or may not have money. And so the IRS loses money because of this problem. The Department of Labor, federal and state, care about misclassification because independent contractors aren't subject to the same overtime and minimum wage laws as employees. So the Department of Labor and the Federal Department of Labor and IRS have different tests on categories on determining whether someone's a worker is an independent contractor or a employee, and the Virginia is going to be using the IRS test. But what this new law means is that if a worker that's been classified as an independent contractor now can sue the employer, can be awarded damages in the amount of wages, salary, employment benefits, and insurance expenses incurred. So expenses incurred by the employee that would have been covered by healthcare if they had healthcare under the employer plan. If they had extra expenses, arguably that comes under what they can sue for. And plus all compensation and attorney's fees. Once again, that's a law. Another law prohibits retaliation against an employee or independent contractor that reports or plans to report a misclassification. The worker must be doing that report in good faith. A worker that feels like they've been retaliated against can make a complaint with the Commission of Labor and Industry, and they can bring an action against an employer who is taking this retaliatory action. Employer could be responsible for reinstating the employee if they've been fired or paying lost wages. There could be civil penalties. Again, a lot. There's also a couple of other laws. I'm running a little short on time here, so I'm going to just mention them quickly. The Board of Contractors of Virginia governs like construction contractors, and they're going to have the ability to sanction contractors that misclassify employees. And we talked a little bit about the construction industry before. And starting in January 2021, the Department of Taxation is going to be able to conduct investigations and assess penalties for misclassification. I think it's coming. I think that states are paying out record amounts in unemployment benefits. I think that there are going to be budget shortfalls. I think that states are going to need money, and this is one way for them to get money. This is going to be one way for them to go after employers and get money. So I think it's coming, 2021. So my takeaway on that is, one, if you have independent contractors, you should have a lawyer review whether they're properly classified. Whether these new laws or not, you should have had that done. If not, you should do it. Most employers that use independent contractors regularly, and independent contractors and employees are doing the same work, have made a risk-benefit analysis that, there's some risks in doing this, but the benefits I get by hiring this person says they want to be 1099, and I need this person. And if I don't have this person, I'm not going to win this government contract. So you know what? I'm going to take that risk. Starting July 1st, this analysis changed. The risks have changed. So that risk-benefit analysis, I think employers need to rethink, do it again. Number two, thinking about retaliation, okay, in this context and in other contexts. Retaliation means discharging or disciplining an employee, among other things. Usually when I'm advising an employee about terminating a particular employee, when I'm advising an employer about terminating a particular employee, I ask, hey, listen, has that employee taken any protected activity recently, like filing an ethics complaint or asking for FMLA leave or some other protected activity? All of a sudden now you have a lot more protected activity that's potentially could cause a retaliation claim. So you really need to think about when you're disciplining or terminating someone, what the risks are in terms of the protected activity, and make sure you've got a really good reason for taking the discipline or termination action that you're taking. All right, real quick here, there's a couple other laws I wanted to touch on. Marijuana decriminalization, July 1st, a new law goes into effect reducing penalties for personal possession, simple possession of marijuana. And what the new law does as related to this is prohibit employers from requiring an applicant to disclose whether they've been arrested, charged, or convicted of simple possession of marijuana. So you may want to take a look at your job applications and make sure you're not asking that question. There's a new whistleblower law, which I could spend an entire hour on alone. It's the first of its kind in Virginia. It's broad. It protects workers from retaliation from basically any perceived violation of federal or state laws. Most of the federal whistleblower statutes say, hey, listen, if someone raises this issue under this law, then they can be, they're protected. This new Virginia law is so broad. It says an employer cannot discharge, discipline, threaten to discipline, discriminate, penalize, take any retaliatory action against an employee because of protected conduct. There is a private right of action, meaning an employee may file a lawsuit in state court in the hotbed of employment litigation, which you don't want to be in. But importantly, the law does not allow an employee to disclose protected data or confidential information. So we'll see how that works out. Okay, in closing, given that, let me do this. All right, given that Democrats control both Virginia legislative chambers and the governorship, that's what got us into all of this, right? And the possibility of a Democratic president in 2021, it's a possibility. There may be more laws coming, okay? Employers should make sure that all of their posters are up, that their handbooks are updated, and their managers are trained on these new laws. But it's not only updating handbooks. Employers need to look at whether they require non-competes. They need to look at whether they use independent contractors, and they need to look up whether they have practices that are setting them up for liability. I know this seems like a lot, because it is. There are so many employers out there, especially now, that have razor-thin profit margins. These new laws, especially the ones with the private right of action, are going to cause a lot of headaches for employers. You know what else is going to cause a lot of headaches? These unemployed lawyers out there that are going to be taking on all these new cases. Employees are going to be able to get into state court where employers do not want to be. It's not going to be easy. Employers cannot ignore this. So there are 3 things that I think employers should do at a minimum. I could give you 10 things, but I picked these 3 between now and July 1st. If it's necessary, maybe it's not necessary, maybe you're all set, but if it's necessary, or if your HR person wants, get your HR person enrolled in some SHRM classes, working towards a SHRM certification or some other certification. Education and knowledge is going to be key in all of this, number 1. Number 2, talked about some posters. You know, you can go to the Virginia Department of Labor and see the posters that you need to post. Make sure your posters are all up to date, you know, when notices are posted. And number 3, this is the hard one. I think it'd be really, really beneficial to do an audit of all of your workers. You want to know all your independent contractors, all your employees, whether they're classified as exempt or non-exempt, whether they should be classified as exempt or non-exempt, whether they're getting paid overtime, proper overtime, how you're tracking it. The goal should be, am I paying everyone properly? Am I paying people on time? Am I putting myself at risk for wage theft or discrimination or other type of laws? So those are my 3 things. If I could have a 4th one, my 4th? No, I was gonna say get your checkbook out, but too soon. I'm not gonna say that. And with that, I'll turn it back over to you, Brian.
Thanks, Pavan. So we do have, those of you that are still in, we've got a few minutes for questions. I see one up. I actually have a question or 2 that I wanted to jump in with, and we'll just use the Q&A feature. So actually, going back to the hotbed, unlike a business-to-business agreement where you can kind of limit where it's held, like how the trial is conducted, whether it's a bench or a jury trial, I'm assuming that with private actions, this is going to be all jury trials. Is that a correct assumption, or could some of these be bench trials as well?
Some of them could. That's a good question. Some of them could be bench trials. A waiver of jury in an employment agreement. You know, there's tests or there's requirements. It has to be bolded. It has to be clear. Employees oftentimes say, "Oh, I didn't really know what that meant." So you know, it's not as clear cut as the business to business context. But yeah, that's a good point. You're going to want to try to waive jury trials as much as possible. Absolutely.
On the wage indexing is, well, if somebody is above that threshold today, right, and then the average wage in Virginia increases next year, right, the calculation increases, and now they're below that, does that then put you in violation if you have a non-compete in place with that person?
The way that so there's 2 calculations that that you're going to have to do. You're going to have to do, to determine the applicable wage for the actual employee, there's a 52-week period that you look at, and then there is, you know, for that wage determination, you're going to look at that. And so you have there's going to be a little bit sort of like figuring out what it is. The way that I read the law is that while the employee is below that amount, you can't enforce, and if it's above the amount, then you would be able to. So it could go back and forth. It could change, and it could also change if the employee takes unpaid leave. And if you look at the total wage over a 1-year period, even though their salary may be, or their hourly wage may be above that, it may fall below it. So that's something to think about as well.
So back to your point, don't be the litmus test or the test case in these things.
And if you're anywhere near this, you need to think about really hard whether that non-compete is really necessary or not, because they're already disfavored They have to. They have under Virginia law, even before this, a non-compete has to protect some legitimate business interest, and they can't be overly broad. So why are you getting to this fight? Like, well, what are you really gaining out of having this non-compete? Yeah, lots of times the answer is, oh, it was just in there. We always did it. And so that's not, and that was fine before. That's not fine anymore. Because of the penalties coming. And if you have a non-compete and you don't enforce it, that's one thing. There's some suggestion in the law that even asking, I think it's starting in January, even asking someone to sign a non-compete when it's not proper could possibly lead to some penalties. So that's definitely something to think about.
See, there's a question here it came in during your discussion on the Values Act. So it says, are sexual orientation and gender identity covered by laws in the district or in Maryland?
DC, yeah, for sure. DC, everything is covered in DC. DC and Maryland, I'm pretty sure. You can't quote me on Maryland for sure. I know that like some counties of Montgomery County in Maryland are very protective. I don't know for sure whether Maryland statewide. I would assume yes, but I don't
know. And with that, I don't see any additional questions. I'll just jump into a couple of closing remarks. If something pops in while we're finishing up, I'll address it. So as you're exiting, there is an exit survey. It takes less than a minute. We would be grateful if you could complete that for us. I'm hosting another webinar next week on workplace diversity and inclusion. And I've got a couple of web series as well this fall, employee life cycle, and I'm working on one on clearances. And based upon this conversation, because while Pat and I had talked about this particular webinar, we didn't talk about follow-ons per se, but based upon his comment about whistleblower, we'll probably have an offline conversation about getting one of those scheduled here, probably later in the summer, but we'll talk offline and you'll hear more about it. So with that, I see some people coming off. So thank you all for your attendance and engagement. And Pavan, thank you for your energy, enthusiasm, expertise, and more importantly, some context, right? I appreciate you kind of bringing it into some experiences that you've had with clients in the past. It's very helpful to kind of see how these things actually come together in the real world. So with that, have a great day. Have a great, finish to our short week.
Thanks, Brian. Thanks, everyone.